A standard traffic check, 90 seconds, perhaps fewer. No speeding, no dangerous driving, nothing that would typically spark a red alert. Yet once concluded, that motorist left without a permit for the upcoming half year. Not since they performed something hazardous, but because they broke a statute that did not even exist 3 weeks prior. That is the section nobody anticipates arriving. The regulations did not merely alter, they moved beneath individuals in real time. And currently, there is one particular statute, number 3 on this roster, that has already provoked over 12,000 summonses nationwide with a typical fine approaching $500. Most of those motorists had no clue they were performing anything incorrect, which prompts a larger inquiry. If the network can apprehend that many folks that rapidly, how many others are cruising around today, fully uncovered without understanding it, since these are not tiny updates. This is not regarding exceeding a few miles past the speed boundary or drifting through a stop indicator. These are structural modifications to how you are permitted to drive, where you may position objects within your automobile, how your auto is watched, and in certain instances, whether your vehicle will even permit you to operate it. And the most frightening portion is you may adhere to every routine you constructed over the past 10, 20, even 30 years and still be violating the statute the instant you enter the street. Thus, before you presume you are safe, there is something you must witness since the tolerance for mistake in 2026 is essentially removed. Hello, I am Jessica, and I devote significant time monitoring how driving statutes progress. Not only what alterations appear on documentation, but how those modifications are truly executed on genuine motorists such as yourself. And what occurred at the beginning of 2026 is not standard. This is the largest alteration in driving rules we have witnessed in over 10 years. Whole states launched new enforcement frameworks, reshaped what qualifies as an infraction, and in some situations introduced machinery that is observing your actions in methods most humans do not even comprehend currently. Thus, if you have been operating as if it remains 2025, there is a very genuine probability you are currently non-compliant without realizing it. And that is precisely how individuals are being captured. Excellent motorists, cautious motorists, persons who have never encountered issues previously suddenly receiving struck with fees, marks, or inferior. What I intend to execute in this film is guide you via all 10 of these fresh statutes, beginning from the ones that appear insignificant but are capturing countless persons all the way to the leading 3 that are generating the greatest monetary and legal injury currently. And additionally importantly, I will display you precisely what you must modify commencing today so you do not transform into one of those figures. Since once you observe how these are being executed, you will grasp why numerous motorists are being surprised and why the subsequent one on this roster is currently costing individuals hundreds of dollars over something that utilized to be entirely regular. For many seasons, there existed an implicit comprehension amongst motorists and the street itself. That transient interval when a sign turns yellow, you possess sufficient time to clear the junction, not anymore. In 2026, that allowance has been totally deleted. 14 states have currently coordinated high-definition enforcement imaging devices directly with traffic signal frameworks, down to the precise millisecond the sign switches red. Previously, numerous of these frameworks permitted a tiny cushion, roughly half a second, granting motorists a practical opportunity to clear securely. That cushion is absent. Now, if your back tires are even minimally behind the line when the sign changes, the framework automatically notes an infraction. No alert, no choice, no agent to clarify your circumstance to. Simply a bill created immediately. And here is where it becomes more hostile. These imaging devices are not assessing whether you operated safely through the junction. They are gauging position with intense accuracy. Your fascia either crossed in schedule or it did not. That is all which counts. In states resembling Florida and New York, these breaches are not merely bills anymore. They are being announced straight to coverage corporations. One error at the incorrect junction could silently expense you significantly more in premium hikes over the upcoming few years than the bill itself. What renders this particularly hazardous is how organic the previous custom still appears. You observe yellow, you compute distance, you proceed. However, that impulse currently functions versus you. The framework is no longer constructed around human assessment. It is constructed around precise scheduling. which indicates the most secure maneuver is not to accomplish it, it is to cease every occasion. Since when the tolerance for mistake declines to zero, even a flawless operator can be caught performing what utilized to be entirely permissible. And what is arriving next adopts that identical zero acceptance mentality and utilizes it within your automobile. You have undoubtedly heard "do not message and drive" more occasions than you are able to tally. However, in 2026, that statute has transformed into something considerably stricter and considerably simpler to breach without realizing it. Multiple states, encompassing California, Ohio, and Pennsylvania, have currently switched to what is termed primary execution for apparatus manipulation, which signifies an agent, or more frequently currently an automated framework, does not require any additional justification to notice you. If a cellular device is in your palm while your automobile is on a community thoroughfare, that solitary factor is sufficient. And indeed, that encompasses when you are paused. Red sign, congestion, drive-through, it does not signify. If the engine is ignited and you are in the thoroughfare surroundings, clutching your cellular device is currently an infringement. What is capturing individuals unexpectedly is how this is being executed. AI-supported imaging devices secured on bridges and patrol automobiles can currently recognize when an operator is clutching an apparatus, even momentarily. You do not possess to be messaging. You do not possess to be browsing. Merely clutching it is sufficient. One rapid glance downwards to alter a track or inspect a notice, and you have currently traversed the boundary. The costs alone are aggravating. However, the greater predicament is what transpires after that. If you participate in a collision and there is proof your cellular device was in your palm, even if you were not liable, coverage corporations currently possess greater advantage to claim that you aided the circumstance. And that can signify diminished compensations or rejected assertions entirely. However, here is where it becomes considerably more accurate and where countless operators are being captured without comprehending it. Even if your cellular device is not in your palm, even if you suppose you are performing everything correctly by utilizing a bracket, the precise positioning of that cellular device within your automobile is currently controlled in manners that did not exist previously. And what utilized to render you compliant might currently be placing you in jeopardy. Until recently, utilizing a cellular device bracket appeared like the accountable answer. Maintain your palms free, maintain your gazes elevated, obey the regulations. And for an extensive duration, that was adequate. However, in 2026, that identical configuration could currently be the precise justification you get cited or inferior, forfeit currency in a circumstance you did not even induce. 17 states have introduced particular positioning statutes that specify precisely where your cellular device is permitted to rest within your automobile. Not generally, not broadly, but accurately. And the phrasing sounds basic initially. Your apparatus cannot block your perception of the thoroughfare, traffic indications, or walkers. Acceptable, correct? The predicament is how strictly that is currently being analyzed. In states resembling California, Arizona, and Florida, installing your cellular device in the middle of your windshield, even if it is concealed just beneath your reverse viewing glass, is currently regarded as an infringement. That positioning, which countless operators have utilized for eras, is currently officially categorized as blocking your forward perspective. The sole persistently secure territories, the bottom right corner of your windshield, or straight upon the dashboard. Anywhere else begins to descend into a gray region that execution is no longer regarding as gray. And this is not merely regarding obtaining detained. The genuine repercussions appear after something malfunctions. There existed a scenario in Phoenix where an operator was struck from behind at a stationary light. Entirely not their blame, however, their cellular device was installed in the middle of the windshield. When the coverage corporations analyzed the event, that detail became component of the review. The contention was uncomplicated. The bracket positioning infringed modified state directions, which suggested diminished situational consciousness. The outcome, their compensation was reduced by 40%. A tiny configuration option transformed into countless dollars forfeited. That is the alteration occurring here. These statutes are not merely executed upon the thoroughfare. They are being utilized post factum to ascertain obligation, accountability, and how much safeguard you genuinely acquire. Thus, even if you suppose you are protected since you are palms liberated, the query currently is, are you located legitimately? Since if not, You are vulnerable in manners most motorists have not even contemplated currently. And that identical pattern, where a regulation extends beyond what individuals anticipate, is precisely what is occurring with the subsequent statute, except this occasion it is not within your automobile. It is what you perform when you overtake somebody else upon the thoroughfare. You currently comprehend you are meant to move aside for police automobiles, ambulances, and emergency transports paused upon the shoulder. That has been typical for eras. However, as of January 2026, that regulation has enlarged greatly. What is currently being titled the All-Vehicle Move-Over Regulation has successfully proceeded national, and it pertains to considerably more circumstances than most operators grasp. If you perceive any transport upon the shoulder with danger illumination illuminated, whether it is a stranded operator, a recovery truck, a shipment van, or somebody altering a tire, you are currently legally obliged to either proceed out of the nearest lane or substantially decrease your velocity, and not merely a slight reduction. In numerous states, the necessity is to decline at least 20 mph beneath the exhibited velocity boundary if you cannot securely switch lanes. Upon documentation, the objective is evident. Guard individuals who are susceptible upon the edge of the thoroughfare. However, in application, execution has become considerably more hostile than operators anticipate. Patrol automobiles are currently outfitted with side-facing imaging devices that watch overtaking traffic, specifically searching for operators who neglect to move aside or slow down sufficiently, and the sanctions illustrate how critically this is being received. In certain districts, this is not merely a traffic offense anymore. It is categorized as reckless danger. That signifies larger fees, marks upon your permit, and in specific scenarios, obligatory courtroom meetings. What renders this complex is that not every circumstance provides you a tidy opportunity to conform adequately. Dense traffic, restricted space, swift-moving lanes, it is not constantly effortless to move aside securely. However, here is the essential. Execution is frequently founded upon what your conduct resembles from the exterior. If you cannot switch lanes, you must render it apparent that you are decreasing pace and answering the circumstance. Since from an agent's viewpoint or an imaging device reviewing the footage afterwards, it is not regarding what you plan to accomplish. It is regarding what it resembled you accomplished. And that transformation from intent to obvious conformity is appearing across multiple statutes this season, which delivers us to the subsequent one, where even something as uncomplicated as activating your wipes can silently place you in infringement if you are not considering one stage onward. There exists an interval most operators do not even contemplate. Gentle precipitation starts descending, barely sufficient to obscure the windshield a tiny, thus you tap your wipes on, perhaps once every couple of seconds. It seems insignificant, customary, almost spontaneous. However, in 2026, that tiny activity currently possesses a legal necessity that is capturing countless operators completely unexpectedly. In 29 states, the regulation is currently definite. If your windshield wipes are on, your headlights must likewise be on. No exceptions for era of daylight, no exceptions for gentle drizzle, no exceptions for periodic usage. Wipes on signifies headlights on. End of discussion. And the execution is not merely originating from agents resting upon the edge of the thoroughfare. In numerous states, traffic imaging devices and automated frameworks can currently recognize this discrepancy. They can distinguish the movement of your wipes and contrast it to your illumination condition. If your headlights are not fully initiated, incorporating your rear lamps, you can obtain a bill in the Postal Service days afterwards, finished with visual proof. That is what renders this so effortless to overlook. You do not get detained. There is no alert. It merely emerges. And here is where numerous operators produce a vital mistake. They suppose their daily running illumination qualify. They do not. Daily running illumination typically only illuminate the front of your automobile at lowered brilliance. This regulation necessitates full headlight initiation, which incorporates your rear lamps as well. If your tail lamps are not on, you are still in infringement, even if the front of your auto appears lit. The fees might appear comparatively compact compared to some of the additional statutes, typically amongst $75 and $200. However, that is not the genuine predicament. The genuine predicament is how smoothly this can transpire without you comprehending it. A rapid tap of the wipes, a abbreviated drive in gentle precipitation, and you have currently traversed the boundary. The most uncomplicated manner to eradicate that jeopardy is to solidify the routine. Wipes on, headlights on every occasion, no consideration necessary. Since as you are commencing to perceive, 2026 driving statutes are not merely regarding substantial errors. They are constructed around capturing tiny daily behaviors that utilize to be innocuous. And once those tiny breaches begin accumulating, the repercussions increase considerably quicker than most individuals anticipate. Since currently, it is not merely regarding whether you acquire a bill, it is regarding how those bills aggregate over era. And in numerous prominent states, the total mathematics behind your driving history has altered. Traditionally, most states tracked offenses over an 18-month duration. That offered operators some respiration area. Previous breaches would vanish relatively swiftly, and tiny errors did not certainly accompany you for extended. However, as of February 2026, states resembling New York, Illinois, and Florida have officially enlarged that window to 24 months, which signifies every bill, every mark, every infringement currently remains with you longer. However, the schedule is only component of the alteration. The weighting of those offenses has additionally risen, and in certain scenarios drastically. Consider New York as an illustration. The boundary for automatic permit suspension has been diminished from 11 marks to 10. At the identical instance, specific offenses have become considerably more costly regarding marks. Overtaking a halted institution carriage, which utilized to possess 5 marks, can currently strike you with 8. Speeding in a building zone, that is currently an automatic 8 marks in certain regions, irrespective of how distant above the boundary you were. And that connects to another immense alteration occurring countrywide: building zone multipliers. In 38 states, any moving offense that takes place in a noted building zone currently possesses dual the marks. Not dual the fee, dual the effect upon your permit. So something that would ordinarily provide you 2 marks unexpectedly transforms into 4. 3 transforms into 6, and it accumulates swiftly. What captures individuals unexpectedly is that these zones do not necessitate active laborers to be existing. If the indicators are raised, the zone is active. You could be traveling through late evening, no building in sight, and still be subject to the improved sanctions. That is where the jeopardy multiplies. 2 seemingly trivial errors dispersed over 2 eras can currently propel you past the suspension boundary, not greater coverage, actual forfeiture of your permit. And once that transpires, the procedure of restoration becomes its own difficulty with charges, waiting intervals, and enduring monetary consequence. Thus, the plan here is not convoluted, however, it is crucial. Regard every building zone as zero acceptance and presuppose every mark you acquire will remain with you longer than it utilized to. Since in 2026, the framework is not merely watching what you accomplish, it is retaining it, weighing it more profoundly, and utilizing it to create considerably grander determinations regarding your capability to remain upon the thoroughfare. There is a tiny element dangling in countless autos currently that most operators do not ponder twice regarding. It might be an air fragrance, a parking voucher, a tassel, something emotional, something that has remained there for eras without ever inducing a predicament. However, in 2026, that identical artifact can currently be the justification you get detained. 14 states have officially executed stricter reverse viewing glass obstruction statutes, and the regulation is as uncomplicated as it is merciless. If anything is dangling from your glass and it is observable to an agent, it can be regarded as an infringement. No exceptions for magnitude, no exceptions for motive. And while the fee itself might seem compact, typically someplace amongst $50 and $150, that is not where the genuine jeopardy originates. The genuine predicament is what that infringement permits. It grants legal administration probable justification to commence a traffic detention. And once that detention transpires, everything else enters into play. Your permit, your registration, your automobile circumstance, anything else that might induce additional citations or complications. That is why this regulation is acquiring notice, not sense of the sanction on its own, however, sense of what it opens the entry to. And what is capturing individuals unexpectedly is how ordinary these artifacts feel. dealer tags, spiritual icons, even lightweight air fragrances. Factors that never seemed like a predicament previously are currently being treated as authentic justifications to detach somebody. Thus, the most secure maneuver here is uncomplicated. If it dangles from your glass, remove it. Since in the present execution surroundings, even the tiniest detail can transform into the inception for something considerably grander. And that notion that tiny adjustments can possess considerably grander repercussions becomes even more genuine when you observe how 2026 is impacting not merely how we travel, however, who is permitted to retain traveling in the inaugural location. One of the most contested revisions this season focuses around operators above the era of 65. Numerous states have commenced distributing obligatory mental screening as component of the permit modification procedure. What utilized to be a basic site examination is currently being broadened to incorporate digital evaluations that assess reaction duration, spatial consciousness, and determination-making velocity. Upon that, fresh doctor reporting necessities in certain locales signify that doctors are currently compelled to inform the Department of Motor Vehicles if they witness indications of mental deterioration that could influence driving capability. The objective is security, however, the suggestions are intimately private. For numerous, traveling symbolizes self-reliance. And currently, that self-reliance is connected to clearing a more intricate and continuous assessment procedure. At the identical instance, another necessity is surfacing in states that encounter tougher climate circumstances. Obligatory tire thread inspections connected straight to automobile registration. In locations resembling Maine, Vermont, New Hampshire, Alaska, and Minnesota, operators must currently reach a minimum thread depth of 4/32 of an inch, twofold the preceding federal foundation. If your tires do not reach that necessity, your registration modification is refused until they are substituted. No prolongations, no provisional endorsements. And that generates a monetary stress location. Since if you arrive hoping for a standard modification and fail inspection, you are abruptly confronting the immediate expense of a full tire substitution merely to remain legally upon the thoroughfare. These alterations might impact diverse organizations in diverse manners. However, they all aim at the identical, fundamental alteration. Traveling in 2026 is no longer merely regarding how you conduct behind the wheel. It is regarding fulfilling a rising collection of circumstances, bodily, mechanical, and regulatory, that determine whether you are permitted to exist there at all. And prior to we advance further, here is something to retain in thought. Most operators are going to get captured by at least one of these alterations simply since they do not comprehend they exist currently. However, currently you do. And that recognition is what distinguishes somebody who gets surprised from somebody who stays preceding it. If you wish to maintain up with how these statutes are progressing, since they are transforming swiftly, ensure you are adhering along. Since what is arriving next travels beyond tiny fees and minor detentions into statutes that are currently generating serious monetary injury, legal predicaments, and in certain scenarios, penal accusations. Currently, we enter the portion of this roster where the repercussions cease being bothersome and commence becoming serious. Since regulation number 3 is not merely capturing individuals unexpectedly, it is converting daily operators into penal situations over something most of them do not even acknowledge is a predicament. And it all descends to your permit plate. In 2026, multiple states have recategorized any kind of permit plate obstruction as a considerably more serious crime. And when we mention obstruction, we are not merely mentioning somebody purposely attempting to conceal their plate. The classification currently encompasses anything that hinders how an imaging device interprets it. Overlays, borders, applications, even entirely translucent shields. The supposition constructed into the regulation is elementary. If it influences exposure to a sensor, it is an infringement. And in states resembling Texas, Virginia, New York, Colorado, Washington, Illinois, Georgia, and Michigan, that infringement can currently ascend considerably past a bill. In certain districts, it is being treated as a felony-level crime, particularly if there is any implication that the obstruction could be utilized to dodge tolls or automated execution. That signifies potential courtroom meetings, thousands in fees, and in extreme instances, a lasting mark upon your history. What is producing this so general is how frequent these artifacts are, dealer borders that partly cover the state title, ornamental borders that somewhat overlap registration stickers, transparent plastic shields that persons installed merely to shield versus dirt or climate. For eras, these were normal. Currently, they are risks. There existed a scenario where an operator purchased a utilized automobile that arrived with a somewhat shaded plate overlay already installed. They did not ponder twice regarding it until they were detained. What succeeded was not merely a citation, however, a legal circumstance that necessitated counsel, cost thousands in fees, and could have escalated further relying upon how motive was interpreted. And that is the vital term here, motive. Even if you did not install it, even if you did not recognize, execution does not constantly terminate at the surface level. If it resembles something that could hinder automated frameworks, it becomes your duty. And execution is increasing swiftly. Agents are being instructed to specifically observe for anything that avoids a permit plate from being ideally legible, not merely to the human eye, however, to electronic frameworks. In certain scenarios, automobiles have even been identified for confiscation if the plate is not entirely compliant. That is how hostile this has transformed. Thus, the most secure and really the sole maneuver here is total transparency. No overlays, no borders, no additions, merely the plate precisely as released, since this is the regulation that is capturing the most individuals currently. And it is accomplishing it without alert. And if that appears intrusive, the subsequent regulation proceeds it a stage further, not by modifying what is upon your automobile, however, by tracing whether you are even permitted to be traveling it in genuine era. The leniency interval for coverage breaks is essentially absent. In 2026, numerous states have completely merged their Department of Motor Vehicle frameworks with coverage suppliers, establishing a live connection that refreshes immediately. The moment your arrangement terminates, is terminated, or even momentarily breaks due to an overlooked payment, that data is conveyed straight into a statewide repository. And from there, it becomes observable to execution frameworks almost immediately. Patrol automobiles, highway scanners, and fixed plate readers can currently identify unprotected automobiles as they pass by. No traffic detention necessary to uncover it. Your condition is currently acknowledged prior to you are even detained. And if you are detained, the repercussions have ascended. In multiple states, traveling without active coverage is no longer treated as a correctable predicament. Agents currently possess the authorization to confiscate the automobile on the spot since it is categorized as an active jeopardy upon the thoroughfare. However, the profound alteration is not merely regarding whether you possess coverage. It is regarding how your traveling conduct is currently linked to it. Contemporary automobiles arrive outfitted with occurrence data recorders, frequently named as black containers. These frameworks track factors like braking designs, propulsion, rounding, and velocity fluctuations. Under revised 2026 arrangements, coverage suppliers are progressively permitted to access a variation of that data or a condensed security ranking when assessing your arrangement. And here is where it transforms into a compromise most operators do not acknowledge they are forming. If you consent to distribute that data, your prices may mirror your traveling habits. However, if you select not to, if you disengage for privacy motivations, some suppliers currently place you into a superior jeopardy grouping by default, not since of what you accomplished, however, since of what you selected not to distribute. So the framework shifts again. You are not merely being assessed by what occurs upon the thoroughfare. You are being assessed by what your automobile reports behind the scenery. And that signifies the classification of safe traveling is no longer merely obvious conduct. It is data, persistent, quiet, and progressively influential. And currently we arrive at the largest alteration of all, one that does not merely modify how statutes are executed, however, alters who or what is genuinely in authority when you are behind the wheel.